Hello everyone, welcome to MediaNama. Earlier this month, the Supreme Court observed that digital access is an intrinsic part of the right to life and liberty. This came as part of a judgment that the court gave while hearing two separate petitions from a group of acid attack victims who were dealing with vision impairment and a blind individual. In both the cases, the petitioners were asking the Supreme Court to direct various government entities to formulate rules and guidelines for conducting e-KYC processes through alternative methods to make the process inclusive and accessible to people with disabilities. The acid attack victims mentioned that the e-KYC process required them to blink as a mark of liveliness. Their difficulties with blinking was making it hard for them to open bank accounts and purchase SIM cards, both of which require people to go through the e-KYC process. Another argument that the petitioners brought up was the fact that facial recognition systems employed for e-KYC do not give sufficient guidance on how to align your face properly. They also mentioned similar issues with selfie based verification, where the lack of accessibility features prevents autonomous completion of the process. While it is mandatory for businesses to carry out offline KYC, the petitioners argued that in many cases, businesses refuse to do so. Besides this, certain parts of the KYC process further add to difficulties for the visually impaired. For instance, the petitioner's lawyers mentioned that the Reserve Bank of India's master directions on KYC prohibit people from prompting during eKYC. This means that a person with blindness does not have any remedies and no one can provide them any assistance during the digital KYC process. In cases where such individuals can actually get help, the officials lack proper awareness to adequately provide assistance. So, what exactly did the court mean? It's very important to note that court decisions and observations are two different things. The comment about digital access is an observation and comes in the context of the fact that digital platforms today mediate people's access to all essential services. This includes governance, healthcare, financial access, so on and so forth. As such, the court believes that there is a need to reinterpret the right to life under Article 21 of the Constitution. It says that the state's obligations under Article 21, read in conjunction with other parts of the Constitution, must encompass the responsibility to ensure that digital infrastructure is universally accessible. The court had observed that bridging the digital divide is no longer merely a matter of policy discretion, but has become a constitutional imperative to secure a life of dignity, autonomy, and equal participation in public life. While not a part of the court's official decision, these observations do establish the importance of digital access in today's world. It builds on the court's existing legal position that internet access is an integral part of the freedom of speech and expression under Article 19(1)(2) of the Constitution. In previous judgments, the court has also notably held that accessibility is fundamental to right to life, dignity, and freedom of movement. It has also stated that a violation of the Rights of Persons with Disabilities Act 2016 is a violation of fundamental rights under the Constitution. So, now that we've discussed what the court said and the context behind this, we should also look at what the actual directions were in terms of accessibility. On the accessibility front, the court has instructed government agencies to follow accessibility standards and appoint a nodal officer in every department to ensure compliance. The court has also mandated regular audits by certified accessibility professionals and involvement of people with blindness in user acceptance and testing phases while designing any app or website, or in case a platform is launching a new feature. With respect to liveliness detection, the court has asked RBI to issue directions that customer due diligence and onboarding of new customers can be done using video KYC process where blinking of eyes is not a mandatory requirement. The regulator also has to ensure that all entities under its purview incorporate alternate modes of verifying liveliness or capturing a live photograph beyond traditional blinking of eyes. Responding authorities also have to ensure that they provide options for sign language interpretation, closed captions, and audio descriptions for visually and hearing impaired users. The responding authorities have to develop alternate formats, including Braille, easy to read formats, voice enabled services to disseminate government notifications and deliver public services, ensuring accessibility for all. They have to establish a dedicated grievance redressal mechanism for people with disabilities to report accessibility issues. They have to establish a helpline which provides step by step assistance to persons with disabilities. Besides this, responding authorities have to mandate inclusion of disability awareness and training modules as part of the e-learning modules for officials in their entities. The responding authorities also have to mandate inclusion of disability awareness and training modules as part of the e-learning modules for officials of their regulated entities for better sensitization of the officials. All entities have to design KYC templates or customer acquisition forms that capture disability type and percentage so as to provide the disabled people with accessible services or reasonable accommodations. Respondents in the case also have to establish a mechanism for human review of rejected KYC applications in case where accessibility related challenges prevent successful verification. Further, a designated human officer will be empowered to override automated rejections and approve applications on a case by case basis. In case you want to take a better look at this case or any of the other judgments mentioned during this case, you can take a look at our website. Thank you.